Okay, hello everybody, hello. I am Cara Shaffer and I am the legal writing specialist at South Texas. Thank you so much for joining me today to talk about legal writing. It's kind of a gloomy Friday, so I really appreciate you tuning in. And I want to dive into the topic of the hour, legal writing. But first, I just want to tell you a tiny bit about the Legal Writing Center, which is a new resource on campus. We've been here for about 14 months. And it's just been an absolute pleasure getting to be part of the South Texas community and getting to work with the students. I'm sure you all already know this, but they're quite lovely. They're great to work with. So the Legal Writing Center, we offer a host of different, We offer a host of different resources so students can actually bring in their drafts and receive some individual feedback and critique on those drafts. We also offer a host of workshops throughout the year on all sorts of different topics, from sort of foundational fundamentals on writing, so punctuation, grammar, style, that sort of thing, all the way to kind of more sophisticated persuasion, rhetorical techniques, editing and revision tips, etc. So we do a lot of stuff in the Legal Writing Center, and I would love to chat with alumni. I haven't gotten to meet too many of you yet, but I would love to chat with you about it if you're on campus in the next few months. So I want to dive into the topic of the hour, and I thought a lot about what I wanted to tell you today. And I thought a lot about what I wanted to say to you today because I knew that I was going to be talking to a group of professional writers, as we all are as attorneys. And because I knew I was going to be talking to this group of professional writers, excellent attorneys, people who cultivate this skill sometimes every day, I had to think a lot about it. And what I came to is that I wanted to begin by sharing with you the most influential piece of legal writing advice I have ever received. And the most influential piece of legal writing advice I have ever received, I was quite a young legal writer at the time, and I knew sort of CREAC and the fundamental organizational principles, but I was very, very eager to improve and to learn the secrets, which I knew there must be many. And so I was listening to a talk by a judge, and he was giving a talk on how to make your writing likable, basically, how to persuade judges, how to write well. And so I was extremely eager. I was leaning forward in my chair. My pen was sort of posed above my notepad, and I was listening so intently to what this judge had to say. And so the judge, he's a judge in Georgia. He's also a professor at Emory and just a fantastic speaker. And so he takes his legal pad, and he sort of holds it up and he surveys the audience, and he looks out at us and he says, attorneys, if you put a piece of legal writing into my hand, no matter what it is, I'm going to look at you and I'm going to look at this piece of writing and I will approach it with suspicion and hostility. And I will not like you and I will not like your writing until you prove to me that you are not going to waste my time. And he sort of dramatically drops the pad. So I was, of course, taken aback as a young legal writer at this point, but as the judge sort of started speaking and explaining what he meant, his advice kind of percolated, and certainly as I got into practice, because I think we all have experienced that moment where somebody puts a virtual or real stack of legal writing on our desk, and we read it, and the first page just sort of makes you have that sinking feeling, because you know it's going to take you many, many hours and perhaps days to wade through those pieces of writing. And so I think what the judge was saying is that we as legal writers have a burden. And of course, we have a legal burden, but I'm talking about a different kind of burden. And the burden that I'm talking about arises because of really two factors. And the first factor is that we are all intensely time pressured. There's so much pressure all the time. We are inundated with work. Every attorney that I know is simply underwater for much of their professional life. And the second factor is that we exist in a field where there is, for lack of a better word, what I would call a lot of underdeveloped writing and what you might call just very, very bad writing. And so because of these two factors, we have this burden to prove to whoever we're writing to, whether it's someone in litigation, whether it's a judge or justice, whether it's in whatever practice field you're in, that we are not going to waste that person's time. And so as a young legal writer, I, of course, wanted not to waste a judge's time. I wanted them to like my writing and like me and not hate me. And so I started poking around in the literature about this, in the scholarship. And so what I came to after reading many, many pieces of writing, someone told me, go read Ryan Garner, and so I did. And someone else told me, go read Ross Guberman, and so I did. And I started reading accounts from judges and justices on how to make judges not hate your writing. And so I did. And what I came to was that everybody says the exact same thing. And of course, they have different nuances. It's all useful and great information, but they all basically say the same thing. And the three things that they all say are basically tell a good story, get to the point, and do it very, very quickly. And so today, I want to talk about three things. And of course, this talk is not just for litigation, persuasive writing. I hope that there's something for everybody. But I want to talk about today three things. First, I want to talk about the reading climate that we're in, the kind of reading climate that we all find ourselves in as readers and writers, and some of the scientific studies, some of the studies that have been conducted both in the field of legal writing and also just about general psychology and writing and how people process information that are really relevant to us today, thinking about our own revision process as writers. And second, I want to give you some tips, and I'm going to be candid with you. I have stolen these tips from the experts, as I will misquote T.S. Eliot. He says, this is a quote attributed to him, but he never actually said it. He says, bad poets borrow and good poets steal. So that is what I've done today. I've just stolen a bunch of tips that I really love. And third, if you are already doing every single one of these tips today, I just want to make you feel great about your writing because you are, as my students say, crushing the game. So moving into this first point about legal reading, and we can be brief here because I think almost everybody already knows this. I know that all of you on the call today are people who are very invested in legal writing. You're people who care about it. You're obviously people who think about it because you've decided to join me at 4 p.m. on a Friday to talk about legal writing. And so if you talk to somebody who cares about legal writing, meaning anybody on the webinar or in the audience today, you will find yourself sucked into a conversation about how terrible our attention span is as a culture today. And it's true. We've all heard the research about how our brains are being rewired because of screens and how screens sort of lead to this process of multitasking where students and everybody really has a hard time just sitting down and reading something straight through. And I coach a team of undergraduate mock trial students, and I asked them recently if they were able to sit down and read an entire chapter of a book, just start to finish the whole chapter. And about half of them said no. I think that what we can all acknowledge is that we are in a very different reading environment than we were even a few years ago. The landscape has changed. And so I think the way that we think about our writing and the way that we think about revision needs to slightly adjust as well. And of course, we need to uphold the integrity of writing in the legal field. But I think that there are certain things that we can all think about. And when we refocus that critical lens, as we all have to every once in a while on our own revisions, because of course, writing is a process that really is never completed, the process of learning how to write well, it's important in this particular moment to think about these tools. So diving in, come on, PowerPoint, work with me here. So diving into the weeds, we're going to look at these first 4 tips. So consider sentence length, cut throat clearing phrases, use the simplest synonym, and avoid nominalization. And so when we are, I want to talk about some of these pretty briefly because I know that they ring a bell for many of us and that they're things we've heard, if not since law school, then frequently in our own practice. But I think that there are some useful things for us to think about with each of these. So for considering sentence length, the average sentence length that these the brightest minds in legal writing tell us we should write are about 20 to 25 words. And I don't know about you, but the last time I checked my actual sentence length, my average sentence length was a while ago. And so I did it before this talk. And it's so easy to creep up. It's so easy. And so I think if you don't know about the Microsoft Word functionality that allows you to actually check your average sentence length, go play around. It's quite illuminating, enlightening. Okay, so thinking about that and thinking about the simplest synonym, I think that when attorneys think about using the simplest synonym, when they think about using short language, short sentences, and plain English, they often think about the counterexample as something like this. And this is an example from Brian Garner's book, The Winning Brief. And the example goes like this. The undersigned hereby extends said lien on said property until said indebtedness and loan agreement note as so modified and extended has been fully paid and agrees that such modification shall in no manner. And I'm not going to finish this sentence because it's kind of a nightmare. It's very thorny. It's difficult to get through. It's hard to understand. And I think that's what a lot of people think about when they think about like bad legal writing. But I think that the point of writing short sentences and the point of this sort of ruthless streamlining of thinking about this sort of economy of the sentence is not so much about, not writing just very long, crazy sentences like that, but it's about taking sentences that aren't so bad but are fine and sort of wringing them out and coming up with this ruthlessly streamlined piece of work. So for example, this is from a professor at the University of Texas, Professor Schiess. Professor Schiess gives us this example. He says, she indicated she had previously encountered this conundrum. And as I would tell my students, there's nothing wrong with this sentence. It's grammatical, it's fine, it communicates the idea that it's trying to communicate. But if you would, with just a little revision work, you can make it shorter and simpler. She said she had faced this problem before, something that's even clearer, even easier to understand, even easier to read. Professor Schiess's second example here, under the circumstances described, a possible action by Ms. Green could well be allowed to go forward. And with just a little revision work, Professor Schiess has given us the sentence, if Ms. Green sues, the suit will probably be allowed to go forward. And so I think as we refocus this critical lens on our own work, what I try to do is take even my pretty short sentences and just make them even more economical as we enter this new era of reading. PowerPoint is really fighting me today, everyone. And another reason why we ought to refocus this critical lens is because of science. And I'm really excited to share some of these studies with you because I find them absolutely fascinating. And in this first one, two professors decided to conduct this study on sort of readability. And so they took, how many briefs did they take? I will find the number. They took 650 briefs. Is that correct? Yes, 650. I'm sorry, they're not briefs. They're motions for summary judgment. And this is at the trial phase. This is at the trial court. And so they take these briefs and they assign each of them a readability measure. So they're looking at things like syllable count, sentence length, all sorts of sort of numerical studies that I don't understand, but they come up with a numerical, like a number that is correlated to readability. And so what they did is that they found when they were looking at the success of these briefs in court is that the readability was strongly correlated with success in this court. And so the data is a little less clear at the appellate level, but here, let me just share with you these numbers. If the moving party's brief was significantly less readable than the non-moving party's brief, the moving party had a 42% chance of winning, but if the moving party's brief was significantly more readable than the non-moving party's brief, it had an 85% chance of winning. And of course, this is only one study, and I think we'd all like to think that these motions are succeeding or failing based on the merits instead of writing factors. But I think that this is at least some evidence that readability and making our sentences short and following these basic precepts that we all learn about in legal writing is so important. It's so important and it has some bearing on our success. So on that same note, throat clearers. So probably everyone has heard of throat clearers. They are the sort of clauses that we stick into our writing that are meant to emphasize a point, that are meant to make it clear that it's very important, but they just don't do a lot of work in the sentence, sort of punching through the meaning of that sentence. So throat clearers would be like, it is clear that, it is important to point out that, it would appear to be the case that. And I think that there's nothing inherently awful about throat clearers. I think that they can be used in a fine way. But I was curious about what the attorneys of the United States are using in terms of throat clearers. And so I went on to Lexis And I Googled, or I Lexis searched just these first three throat clearers. And it turns out in the last calendar year, so the last 12 months, there were 30,000 discrete briefs and motions that use just these three clauses. And we Texans are responsible for about 3,000 of those. And so I think what that suggests to me is that people are using these phrases not in an economical manner, not really thinking critically about them, but instead sometimes maybe as a crutch. And so I think in my own work, what I take this to mean is that I need to carefully examine the phrases that I use over and over. And I think we all have phrases like that that sort of creep into our writing. And so I think that is sort of the homily on throat clearers and why they might be problematic. So effective short sentences, I use this lovely example by Justice Kagan later, so I'm going to skip over it for now. And I want to go on to nominalization, a thrilling, exciting part of my presentation. So if you don't remember what nominalization is, it refers to using a verb or an adjective as a noun. So it tends to add a bit more words to a sentence, it gets a bit cluttered, and it can also sort of cloud the clarity because readers expect that verb to communicate something about the action of the sentence. Whereas in a nominalization, when using nominalization, you're using a verb that's kind of acting as a noun. So for example, Smith came to the conclusion would change to Smith concluded. So conclusion in that first one is obviously acting as a noun. So the reason that nominalization is bad, obviously because of what I just said, but also because it tends to be used adjacent to other parts of speech that don't add a lot to our sentences and that can just tend to clutter the sentence and make it less readable and less clear. And so, for example, nominalization frequently comes after an empty verb. Like in this example, the contestant has winnings. So has being our empty verb here that isn't giving us much information about what is going on in the sentence. Secondly, nominalization often follows there is or there are. So these would be sort of expletives that also aren't doing much for a sentence. They're just sort of there in the sentence. As in, there is a requirement for further study into the origin of this disease. Nominalization often exists on both sides of a prepositional phrase, which I love prepositional phrases, but they're also sort of key red flags for things that can kind of clutter a sentence. He conducted an investigation at the start, and nominalizations frequently consist of nouns that constitute abstractions, which of course can also cloudy the clarity of a sentence. So his development reflected years of dedication. So moving on to this next set of streamlining advice from the sages in the field, we always want to put subject and verb close together, close to the beginning of the sentence, and connectedly, we always prefer the active voice. And I know that we have heard this advice ever since law school, but it's worth a revisit. And it's worth a revisit because there is some evidence that using passive voice actually activates a different center of the brain. And it activates a center of the brain that is related to handling higher syntactic complexity. So it's actually activating a part of the brain that deals with harder things, with more difficult information to process. And so when you put things into passive voice, you are actually forcing your reader to do more work than if you put it into active voice. So just a very, very brief overview of passive voice in case you haven't reviewed in a while. So bones have been broken. So bones have been broken. This is the most ominous sentence in the English language. And it's ominous because we don't know anything about the sentence. We don't know whose bones have been broken. We don't know who broke the bones. And so if we flip it around into the active voice, it becomes Emily broke her arm or Emily broke Amy's arm. So to briefly go over that, and I keep typing on my laptop when I'm reaching for this other computer, it's very complex. So the active voice. In the active voice, the subject of the sentence does the action. And in the passive voice, the subject receives the action or is acted upon by the verb. So in this example, is it showing? I hope that it's showing on the screen share. I think it is. I think it is. mysterious. Anyway, so the affidavit was submitted by the attorney, is our example. So when identifying passive voice, which we're in here, we want to ask what is doing the action of the sentence, and it's this phrase was submitting. And so who or what is submitting? It's of course, it's not the affidavit, it's in fact the attorney. And so if we flip it, it becomes the attorney submitted the affidavit. So the attorney here is the subject. The attorney is doing this action. And so we front loaded the subject and the verb. It's clear, it's elegant, it's sophisticated, it's beautiful. It's an active voice. Okay, so the easiest way to identify passive voice in your writing, if you're not used to just kind of finding it, is to control find for these three words. So by, is, or was. So anytime you have a to be verb, so is, was, were in your sentence, that's a red flag that you may be in passive voice. And anytime you have the word by, so I tell my students that if they can add the words by zombies to the end of their sentence and it's grammatically correct, they are in passive voice. So for example, mistakes were made. We know that we have a to be verb here, it's were. We flip it around and it becomes the lawyer, who's the subject, made mistakes. Okay, so moving on quickly from passive voice into this next set of advice. So this has to do with story and clarity. So we're looking at sentence structure here. So these are all micro level suggestions here, kind of about the nitty-gritty of our revision process. So these are front load key information, chain ideas, old before new, focus on character at the sentence level, and use parallel structure. So before we get going, I want to share a study with you, which is not really a very scientific study, but I like it anyway, on why using story, even at the sentence level, is so important, because there's so much evidence that humans process information through narrative. We naturally do it. We naturally sort of process information through chunks of ideas. And so to test this theory, two journalists at the New York Times decided to buy a bunch of junk. And so they bought a bunch of junk from eBay. They bought 200 pieces of junk. So knickknacks, sort of plastic stuff, things that were all less than $2. So they didn't buy anything over $2. And included in this junk was a horse head, a beautiful horse head. It's about this big, and it's worth about $1. It's worth about $1. But the journalists then wrote to a bunch of authors, and they asked them to write a story about each of these pieces of junk. And so the authors did that, and so the journalists then put the horse head and all the other junk back on eBay. They opened it up for bidding, and they added this story in. And so I don't exactly know what's on your screen, but the thing that was revealed by this study is no longer did this horse head go for $1. It instead went for $80. And so it's stunning. It just illustrates how driven we are by narrative. And so it's so useful if we can include it even at the sentence level. And so there's actually a study done by some law professors on this importance of narrative, even at the sentence level. And so in this study, they sent briefs written for a fictional case to 95 judges, clerks, staff attorneys, practitioners, and law professors. So these are people all across the spectrum who are doing all sorts of different jobs, all different sort of points in their careers. And they asked these people to review two different briefs. And these two different briefs, one of them, they argued the same law, but one of them used narrative and argued within a narrative structure, and the other didn't. It just sort of laid out the legal facts and the legal argument. So what it showed was that 64% found the narrative briefs more persuasive. So about a 2/3 majority. So there's some evidence that this is really important to us in legal writing. And I think all of us know that intuitively, but it's just, for me, it's fascinating to know the sort of statistics behind the truth. So front-loading key information and specifically focusing on character. So we know that humans process through narrative. We know that we like to have an actor, a character, and also we like to know what that actor and character is doing. And so if we can do this in our sentences, the science shows that our readers will be more invested and more easily processing this information. So the key sort of detractors or confusers from this sort of structure are dependent clauses or intro clauses sort of stuck at the beginning of sentences. So after falling in the practice and suffering a concussion, the athlete could not compete according to team officials. So nothing wrong with this sentence. It does a good job of explaining what's going on, but we don't really know what the important actor and action is that we don't know what the actor and action are in the sentence that we're supposed to focus on. And so with just a bit of revision, team officials decided the athlete would not compete after she fell in practice and suffered a concussion. So we now know who the actor is that we are supposed to be focusing on in this sentence. And of course, it's not possible to do this unless you know the facts of the case. So the second illustration, the tendency of at-risk families to try to protect their children from judicial oversight is well known. Well, it's well known by who? And so this becomes family court judges know that at-risk families try to protect their children from the court's oversight. So as I said, generally this narrative character structure kind of gets lost when you have a dependent clause stuck in the beginning of a sentence. And of course, there are times when this is useful. We all use this construction. Sometimes it's just necessary. But I think it's important to just sort of think when we're refocusing our critical lens on our own revision into what sentences it might be useful to remove this structure from and use a more front-loaded character narrative structure. Okay, so chaining. So chaining refers to a couple of different things. So if a sentence uses an important word or phrase, situate that phrase early in the next sentence, and situate old information before new information in a sentence. There was a study done at Carnegie Mellon, and it showed that when readers were processing information in sentences just like this, these ones that I'm describing, where information was entered slowly through multiple sentences, and they were sort of chained, and let me read you the exact language. Subjects of the study were more adept at identifying the main point of the paragraph if sentences progressed in a manner that allowed each sentence to reference an idea or concept that had already been introduced to the reader in a previous sentence. So there's some evidence that shows that this chaining effect makes it literally more people more able to process the information and understand what we're saying. So I really like this example. And this is from a brief of a petitioner in Hooper. So it reads, federal law requires airlines to report to the TSA and any and all potential security threats to civil aviation. To encourage such reports, the Aviation and Transportation Security Act provides airlines with a broad grant of immunity, shielding them from all civil liability, including liability for state law defamation for disclosing potential threats to aircraft or passenger safety. The only exception to this immunity is for disclosure made with actual knowledge that the disclosure was false, inaccurate, or misleading, or with reckless disregard as to the truth or falsity of that disclosure. So this author does a really nice job of slowly introducing information and chaining in the next sentence what the main point of the former sentence that he's been talking about. So the next point that I want to talk about is parallel repetition. This is, of course, a connected idea, and it just means repetition of a word or phrase to begin successive clauses. But I want to just point out this really nice example by Justice Gorsuch in case anybody wants to incorporate more of this parallel repetition into their own work. I think his example is really nice. The problem with this line of argument is fundamental. Put to the side the question whether the savings clause was designed to save not only state law defenses, but also defenses allegedly arising from federal statutes. Put to the side the question of what it takes to qualify as a ground for revocation of a contract. Put to the side for the moment, too, even the question whether the NLRA actually renders class and collective action waivers illegal. Assuming, but not granting, the employees could satisfactorily answer all of these questions, the savings clause still can't save their case. So using this parallel repetition, sort of breaking down what's going on in this paragraph, Justice Gorsuch does such a nice job of using this parallel repetition to just sort of put aside all the matters that he doesn't want to talk about. Okay. So connected to this, of course, is transitions and sentence openers. And I think we all have sort of pet transitions that we use, mine is however. And I think as I read writing, what I sort of observe is that most people have three. Most people have three pet phrases that they kind of rely on. And so I think as we sort of refocus a critical lens on our writing and revision, my encouragement is that it can be really exciting, well, at least for me, it can be really great to read a paragraph that uses precise and varied transitions. And so I want to share with you this example from Shiraz hookah versus City of Minneapolis. So as noted, although the ordinance does not single out any particular type of tobacco seller or buyer, Shiraz alleges that the ordinance effectively creates a classification between, on the one hand, hookah shops and hookah smokers, and on the other hand, cigar shops and cigar smokers. Assuming that Shiraz is correct, the ordinance nonetheless survives rational basis review. To begin with, regulating smoking in public places for protection of public health is plainly a legitimate government purpose. Shiraz argues, though, that even if the city has a legitimate interest in regulating smoking in public places, the city still has not provided a rational basis for effectively banning tobacco sampling at hookah shops. So I think this author has done just a superlative job of looking at these different transitions and pulling apart the different parts of his writing where he wants the reader to take pause and where he wants them to move through more quickly. So I think these transitions and signposts are just a great way to sort of vary your writing a little bit, to take a look at ones that you might not have been using so much, but that can really move a reader through quickly, can make it more effective, can make your writing more clear. Okay, so monosyllabic sentence openers, I wanted to mention very briefly, just because I know that some people don't like them, but I want to encourage everyone to embrace them because I love them, and so does Justice Kagan and Justice Gorsuch, actually. So I love this example from Justice Kagan. This is also my example for really effective short sentences. None of them even come close to 25 or 20 words, but it's still so effective at moving you through her argument. Given those good reasons for adhering to stare decisis in this case, this court would need a very strong justification for overruling Roulat. But traditional justifications for abandoning stare decisis do not help Kimball here. First, Roulat's doctrinal underpinnings have not eroded over time. The patent statute at issue in Roulat is essentially unchanged, and the precedent on which the Roulat court primarily relied, like other decisions enforcing a patent's cutoff date, remains good law. So it's sophisticated, it's simple, it uses those monosyllabic sentence openers, and it's just so clear and lovely. And I apologize if I'm butchering the name of that case. So I think when we think about all of these, sort of tips from the experts taken together, I think the reason why it's so useful to think about them right now in this moment is because everyone now is kind of a chronic skimmer. At least we try, I'm sure not everybody in the world is, but I think everybody is sort of moving towards that place. And as much as I encourage my students to carefully and sort of slowly read every single word, the evidence shows that they are doing instead this. This is the F pattern. So I don't know whether you've seen this before. It's something that people who talk about legal writing and writing in general like to talk about with horror. And the F pattern sort of showed up for the first time when they were looking at how to design websites. So they were thinking about how to draw a reader's attention on a website, but it turns out that it actually applies to all sorts of other reading as well. So the F pattern refers to the I pattern of a reader. And these images come from eye tracking software. And you can see that the red is where the reader spends the most time. That's where their eye focuses on the most. The blue is where their eye focuses the least, and the yellow is somewhere in the middle. And so what this F pattern shows is that, perhaps readers are reading every word, but they're reading some words more than others. And so when we think about what we're doing in the law, we should also think about this F pattern and the chronic skimming study, which I'm about to share with you. So wondering about this F pattern and if it held up in attorney writing, they tested people before they went to law school and people after they were already in law school. And so what they found in this study was that actually the F pattern is more distinct in people after they have been to law school, because we learn to read based on looking for these various things in a case. And so it's not that everyone is always using this pattern to read all the time, but I think it makes those organizational units of writing so important to think about. And some of those, of course, are headings, roadmaps, signposts, transitions, front-loading key conclusions in a paragraph, front-loading key conclusions in the document, short paragraphs, white space, bullet points, all of these sort of formatting things that make a document easier to look at. And I think using these, it helps us uphold the integrity of the actual writing, because it helps readers orient themselves, even if they are using this F pattern, even if they're using that to sort of figure out what they ought to read. And so, some quick revising tips that I want to share as we sort of wind down this presentation. So when we are editing, I'm sure everybody has had the experience of editing the same thing sort of over and over again. And as you read, you cannot process that information in the same way because it seems like it's the same. You're looking at the same thing over and over again, even when you change it. And so the science tells us, and maybe you've heard these before, the science tells us to edit in a different font because it actually changes the way our brain looks at that, and it makes it think that we are seeing something new. Similarly, if we edit backwards, if we edit paragraphs from the bottom up or sort of in a random order, this also tricks the brain into thinking we're looking at something discrete and new. And the same thing for drafting and lists. If you're fighting with a paragraph and it's just not working for you, try pulling out every sentence into a bullet point or in a list. And sometimes your brain will reconfigure it and tell you what you need to do. So the thing that I want to end with, and I realize now that I've spoken a little bit too fast, but what I want to talk about finally are intensifiers. And so intensifiers are those words in language like clearly, absolutely, and completely. And these words that show emphasis are very much maligned in legal writing. They're maligned, we don't really like them. I tell my students not ever to use them. And so the final study that I want to share with you looks at these intensifiers. And the study asked whether or not using these intensifiers was actually connected with a lack of success, in front of judges, whether judges ruled less favorably in briefs that had these sorts of intensifiers. And so the study showed, and just to briefly go off topic for a moment because I'm a little bit ahead of schedule, this still is from Billy Wilder's Witness for the Prosecution, which is based on an Agatha Christie novel. And if you haven't seen it, I highly, highly recommend it. It's just, it's my favorite movie about the law. It's hilarious. But what they found in this study, and they picked about 800 briefs from 400 random state and federal cases. And what they found is that there was a correlation between losing an appeal and a higher level of use of these intensifiers. But what they found is that in those briefs, what they found was that briefs with a high level of these intensifiers fared better if the judge also used a high level of intensifiers in his or her opinion of the case. And so I think the sort of conclusion here is, know your audience, know your judge or whoever you're writing to, and clearly, absolutely, and completely tell a good story, do it directly, and do it more quickly than you were doing it before. I'm sorry to end a little bit early today, but thank you so much for joining me. If any alumni out there are interested in chatting about the Legal Writing Center, I would love to chat with you if you're on campus. And thank you so much for joining me on this Friday afternoon to talk about legal writing.